Live. Good afternoon and good evening to those of you who are in Eastern Canada. My name is Gillian Maxwell, and I'm a founding board member for the Canadian Psychedelic Association, and I'm delighted that you're able to join us for the second round of our Exploring Legal Pathways discussion. The first one was a couple of months ago, and our panelists, our legal advisors, joined us, and we got into so many amazing discussions that we really wanted to, and actually we didn't get to your questions, so we wanted to do the next round, which is this afternoon right now, and have you answer the questions that are on your minds. Of course, we do have a couple of things to cover before we get there. Won't take too long. Initially, I'm Gillian Maxwell. I'm, as I said, board member, proud to be a board member of the CPA, former board member of MAPS Canada, and I've been working in drug policy reform and harm reduction for a long time, over 20 years, and this is the next phase of my drug policy reform work, is working with the Canadian Psychedelic Association. So I'm going to ask our wonderful guests. We have two at the moment who are with us, and a third one will be joining us in about 20 minutes or so. So Jennifer, would you give a short introduction to yourself so we know who you are, please?
Hi, I'm Jennifer Tobe. I am an administrative law lawyer practicing in the area of cannabis and drug laws. I have a particular interest in moving new drug policy forward and the legalization of controlled psychoactive substances.
Welcome, Jennifer. And David.
Yeah, thank you. Really happy to be here. My name's David Wood. I'm a lawyer and patent agent, and I am general counsel and chief legal officer at Psygen Industries Limited. Psygen is a contract manufacturer waiting for their dealer's license to issue. And as you can see on their website, psygen.ca, they have a plan to manufacture GMP-compliant drug substance for use in clinical studies. And the first substances that are a priority for Psygen are psilocybin, LSD, MDMA, and DMT. But they have plans to manufacture many others, including 2CB and mescaline, and very excited to be part of the team. Been working with Psygen as external counsel for the last year and a half or so, and I'm very happy that I'm now in-house counsel with them. I also run a small, very focused solo practice on the side, and again, very happy to be here.
Well, it's just lovely to have you, David, and I think Psygen is very lucky to have you join their team. And we're at the CPO just delighted to have the two of you available to us when we have questions that are in your realm. And you're always so helpful and give us the benefit of your wisdom. So thank you both. So just a couple of things before we move on to questions. And we thought we'd give you a little update on the legal frontier. And the first one is to tell you that the CPA is spearheading a coalition that is petitioning the Parliamentary Review Committee on the medical assistance in dying legislation. We're specifically asking for psychedelic psychotherapy to be included as an option for those considering assisted dying. We're in the middle of a Hill Lobby Week, which of course is happening on Zoom these days. So much easier, having already spoken to many members of Parliament, and it's fair to say every one of those meetings has been amazing. MPs are listening. Stay tuned for updates. CPA doing its thing. And a couple of other ones to tell you about. A couple of things happened yesterday, actually. A bill to legalize possession of psychedelics in California was approved by the California Senate yesterday, June 1st. It passed 21-16. If enacted, the bill would remove criminal penalties for possessing or sharing numerous psychedelics, psilocybin, DMT, ibogaine, LSD, and MDMA for adults 21 or over. I would say that's another nail in the coffin of the war on drugs in the US. Closer to home, yesterday, the city of Vancouver, British Columbia, unveiled its proposal to help Canada asking for an exemption to federal possession rules, essentially decriminalizing possession of a small supply of all drugs, including heroin and meth. This comes as the BC coroner reported that in April, it was a record-breaking month for drug overdose deaths from people using a tainted supply of currently illegal drugs. At least 176 people died in April, bringing the total in 2021 to 680. That number, the first 4 months, is more than halfway towards the total number of deaths last year. Let that sink in for a second. As well, the city of Kingston took a step forward and unanimously endorsed a motion to decriminalize all drugs. Things are happening. So there's other things happening in our country too, which I know you are all aware of and that we felt that we have to reference before we move into our discussion. It's impossible to move forward without acknowledging the discovery of 215 grave sites of Indigenous children in a former residential school near Kamloops, BC. So I'm actually asking all of us to stand for one moment and acknowledge that by being in silence for one moment, please. Thank you. Something comforting about standing in silence and listening to the birds. Life does go on. I'm just going to read you a couple of paragraphs written by one of our board members, Yasmin Purazek, who is an Indigenous person, and we wanted to tell you what she had to say yesterday. We grieve the loss of the children found in the mass burial in BC. We mourn the loss of the generations of teachings that these families and children represent. We understand that this burial is not the only one, and colonization casts a dark shadow in Canada. Healing these traumas has been a challenge for many of us personally and the communities on Turtle Island. We are still feeling the ripple effect of the hurt today. We may not know where our children are or have gone, and we just feel the holes left in our heart. These truths are painful and are part of reconciliation. The truth is what can help us. The truth is what can help us to heal, even with the difficulty of this painful knowing. We are resilient. We need our medicines to help us recover what we can. I put my tobacco down for the hurting and pray that this will be a step in our healing and not be forgotten. Thank you, Yasmin. One more piece about this. It was just to say, you know, as Canadians, it's our responsibility to learn about our history, to learn about all of this. And here's some things that you might do to support the Indigenous people of Canada. It's simply not enough to wear an orange shirt or put a frame on your Facebook page. I'm going to just run through them really briefly. Learn about residential schools, learn whose traditional territories you live on, read the Truth and Reconciliation Commission's 94 recommendations, contact your MLA and MPs and ask for all school grounds to be searched. Ask them for clean water, for our First Nations. Follow Indigenous educators to diversify what you learn on social media. Have conversations with your inner circles about this. Support Indigenous-led organizations. Be respectful, kind, and patient towards trauma survivors. We reaffirm our commitment to cultural safety and humility within the Canadian Psychedelic Association. We reaffirm our commitment to the decriminalizing of all currently illegal drugs and destigmatizing the people who use them. We believe the use of psychedelics and plant medicines are important tools in healing the trauma and connecting humans to their spirit and their soul journeys. May we all be free from fear, anger, and delusion. Please join the CPA in a couple of weeks on Wednesday, the 16th of June at our usual town hall time when Yasmin will be hosting a special webinar to inform all of us about the history of Canada and the First Nations and what we can do, how we can move from grief to action. And I say that, in memory of Bud Osborne, this wonderful man who founded the Vancouver Area Network of Drug Users. I'm honored to know him, have known him, but he was a tireless, wise soul who never gave up. Not quite sure how to segue into our regular programming from that. It just felt really important for all of us. We had a board meeting this morning just to acknowledge it and talk about it and feel it. And I guess it's really just to say we're in solidarity. This is no longer an Indigenous problem. It's our issue for all of us humans that live on Turtle Island to solve, to be part of. The reconciliation, the true reconciliation is only just beginning. So, okay, here we are, taking all that off for now. And here we are, okay, back to our regular programming. Again, thank you, all of you, for joining us and sending us the questions. And we're all ears and we're ready to engage. I have a few questions that were already received because we asked for questions a little while ago. And so my plan, we'll see how that plan goes, is to say the question and then see who wants to answer it. And if more than one of you wants to answer, please do. And if you want to discuss whether that's the answer you would have given and you think something else, please do. And let's begin. So this is from Trevor Mack. What precedent can Indigenous nations set in regards to fully legalizing plant medicines for ceremonial use? Who wants to do that one? Jennifer.
Well, I can start. But first, I have to say that today's discussion is general in nature and should not be considered as legal advice. And if you need legal advice, please seek legal advice. I'm not going to answer this question directly. I'm going to segue into a discussion paper I've been working on recently, subsequent to our last meeting at CPA, where I think that we need a regulation for traditional medicines that contain controlled psychoactive substances. And I have done some outreach to find out what Canadian Indigenous concerns might be with regards to traditional medicines that might contain controlled psychoactive substances. I had a fair expression of cultural misappropriation. And that there's people feeling that there's a history of being burned if medicine knowledge is shared, and that perhaps participation in a regulation would be an afterthought. So I do think that there is an opportunity for a claiming of space if there are those that are interested, particularly in the ceremonial usage area. The regulation that I'm suggesting specifically is for medical and spiritual or religious purposes. But I think that David might be able to say something interesting about cultural misappropriation in Canada. So I'm going to pass it over to him for a bit of a chat.
Yeah, thank you, Jennifer. And likewise, anything I say during this presentation is not legal advice. It's just my general thoughts, and shouldn't be taken either as any specific position of SciGen. It's again my general thoughts. And beginning with the cultural misappropriation point, I mean, it's just a fact that a lot of very useful technologies, let's call them, I mean, ayahuasca in my mind is a technology, a combination of two plants. That's a technology. At some point, ayahuasca might have been patentable. It's not now, certainly, because it's well known what it is. But the point I'm making is that it's when a culture of any kind has something that is unique and particular to that culture. Some countries, I believe Brazil might be one of them, don't quote me on that, I'd have to double check, have actual laws in place that protect the application of traditional knowledge if that application is commercialized. I'm not aware of any law of that nature in Canada, and it's important to remember that international law is more of an idea than a fact. Like, laws, for the most part, are specific to the countries, the provinces, or the cities that they have effect in. And I just saw something about Section 56 exemptions in the questions, but I'll just maintain the course I'm on here, which is a company that's commercializing something that might have a traditional, indigenous, or other traditional source. They're free to give back. They're free to, do the right thing and make a contribution back to those that were the inspiration for their technology and their product. But in Canada at least, they're not required to do so. But I know that investment patterns especially among younger people now, are changing, and double or triple bottom lines are becoming important to people. And I know that some companies are respecting that and consider it part of the value that they're offering to the market to be that they are trying to recognize this. So that's a cultural misappropriation point. And then how a First Nation in Canada could take initial steps towards their own decriminalization. I'm far from an expert on this. Doug White, who joined us last time, is an expert on this, and he was not able to join us today. But I will say, what I can say is that on a First Nation, due to the way our Constitution works, and the somewhat unfortunately named Indian Act works, and how treaties work, it is possible on First Nations for laws to apply that do not apply in other parts of the country, including in other First Nations. So this has been done with cannabis. There are many First Nations that are sort of running their own industries. Those industries cannot trade cannabis with the federally regulated industry in either direction. That might change one day, but today they can't. And if a First Nation chose to, let's say, remove criminal sanction for something like possession of psilocybin mushrooms, which it's my understanding were used traditionally, at least on the West Coast, it's my understanding they can do that. But I don't want to speak out of school. And again, this would be a question for Doug White, the panelist who is unable to join us today. So what I can say is that First Nations are able to have laws that are specific to their nation. The limits and the extent that they're able to do so, I can't comment on.
Thank you. So we have our third guest has arrived, and even though it looks like he's David Wood, he's actually Rob Laurie. His name just shifted over. That's beautiful. Magic happens. And why don't we have you introduce yourself for a minute or so, Rob, and then I'll fill you in on where we're at with our questions. Welcome.
Thank you. Nice to see everybody. Apologies for my lateness. I was preoccupied and involved on some other stuff. Anyway, I'm Robert Laurie. I work as a plant medicine lawyer. My own practice, Ad Lucem Law Corporation, where I represent effectively cases of all sorts of a constitutional, criminal, and corporate commercial nature involving cannabis and psychedelics. And yes, I have some First Nations experience. I'm currently working with a number of different groups. And I guess it would be appropriate to start off by saying that I am appearing today from the traditional territories of the Nanaimo people in Nanaimo, Vancouver Island. And I'm very excited to be here. That's just one hat. The second more recent hat, I've recently become Chief Legal Officer, and I'm a co-founder in a company called Levity Labs. So I've got my fingers in many pies, and also advise for probably four or five of the leading psychedelic advocacy groups. So I get a pretty good idea what's going on and who's doing what and what we collectively need to do. So enough about me. Let's get back to the group.
Thank you. Welcome. So our original question, there's two questions from Trevor Mack. It's about the precedent that Indigenous nations can set in regards to fully legalizing for ceremonial use. And the second part of his question is, can Indigenous nations proclaim to legalize plant medicines to ensure therapeutic research and economic opportunities happen for their people?
Well, it's a great questions, and especially in light of the very sad and tragic news that we're learning and being forced to confront with First Nations and residential schools. I think it really is an interesting time for First Nations. I think, given the recent events, they will be given a lot more leeway when it comes to how they will reconcile their issues with the federal government on one hand, but also how they will address the issue of therapy and healing intergenerational trauma going back hundreds of years in this country. As to what they can or should or how it works really depends on the band, where the band's located, what rights or treaties, if any, have the band signed. It really depends the issue of sovereignty on who you're talking or dealing with and what you're proposing to do. A lot of the powers, of course, are limited to sovereign territory, which really is another word I like to call self-regulation, because ultimately First Nations can do, to some extent, whatever they want on their land, and they can proclaim whatever laws they so should desire. It really boils down to, will the federal government recognize these rights? Will other companies or countries recognize these rights with respect to enforcing contracts and other, commercial particulars? But really, how First Nations and what legalization or access to food, social, and ceremonial purposes. I mean, I've done a number of hunting and fishing cases, and while there are licenses for food, social, and ceremonial purposes that Department of Fisheries and Oceans grants, for example, with respect to certain hunts and certain species at certain times of the year. There isn't anything formally like that with psychedelics, but if the right band in the right place at the right time can make the right historical and traditional arguments, again, they have to demonstrate pre-existing use in a relationship with these substances, of course, prior to contact, to fall within the Section 35 Indian Act test. So the future, I think, is wide open. First Nations really need to be in the driving seat on these issues. And that's been a real part of my practice lately, given the work and how I've done it in the past. First Nations groups have actually been reaching out because they want to know how to structure their activities, align themselves with the law, and how to use, very much a page out of Malcolm X's book, how to use the laws of the land and the wording of the European cultures against them. And ultimately, that's where, for me, it's an exciting honor and a real challenge to be invited into these circles and be regarded as, in some regards, a fire keeper or a tradition keeper. Because really, in order to make arguments with the federal government as to why a group should be given a special status or an exemption to do something, comes down to the facts and the specifics. And well, of course, that's not uniform across the board with these groups. So really, it comes down to, with First Nations, it's like, well, what do you got? We got to know what all the pieces are. Let's put them on the table and then figure how do we move them vis-a-vis dealing with federal or provincial departments. But for me, it's an exciting time, and as terrible and as tragic as the latest news is, I'm confident that more and more people now who are in denial about the atrocities and the way that First Nations have been treated since the very beginning, well, we'll start to look at there are alternative views of history, and what we were taught in school to some extent needs to be re-examined, just like our psychedelic laws and regulations. So good place to leave it there.
Thank you, Rob. Either of you two want to add to that? No? Okay, lovely. Thank you for that. Next question from Gilham K4. Can we recognize a universal psychedelics right, a fundamental right of every person? Who wants to go? Now, I know Rob always wants to go.
I don't want on this one. I want to hear the others so I can shoot them down for it.
No shooting allowed, Rob, remember?
Each other.
Jen.
I can just say a short statement to that. Regulated right to access.
Yeah, I mean, in Canada, we have a Charter of Rights and Freedoms. Accessing psychedelics is not a protected right. So, in that sense, no, not in Canada. But people can be very creative and forceful with what some of these rights mean. And we have the Charter to thank for the path that cannabis went from being a controlled substance to 20 years later being a consumer packaged good that you can buy anywhere you want. In any province, not anywhere. Now, but again, to Jennifer's point, regulated, like the package has to look like this. It has to have all this information. It has to have this warning label. No, you can't just do it anywhere you want, depending on the province. So, but I also think we don't have an absolute right that's unrestricted in any way to almost anything. There are laws that limit our freedoms to do things, such as discharge a firearm. I can't do that in city limits in Calgary, and I think that's a good law. So the whole concept of laws inherently limits freedoms, but it does so in a way that allows kind of more than 10 people per square kilometer to exist without chaos. So I don't think there's an inalienable right that we can just point to and say everyone has the right to cognitive liberty. I would support something like that, but I would also be interested in seeing it regulated. Just like skydiving, I think anything that carries some inherent risk, I'm generally not in favor of saying to someone, look, protecting you from yourself means you're never allowed to do this, and if you try, you go to jail. That's very heavy-handed, and it makes sense for something like murder or treason. But I've never really supported the idea, which is a requirement to being a member of the UN Conventions on Drug Control, that you have to take away someone's liberty for possessing a drug, or a narcotic or a psychotropic substance. But as we've shown in Canada, after 2.5 years, you can sell these, and it's okay. It's okay. Like, it doesn't make everything burn down.
Mm-hmm.
maybe we'll do the same thing with psychedelics, but I don't think anyone should count on that happening.
Thank you, David. Jen, how about you?
I have a question for Robert. What do you think about the constitutional religious right to access?
That's what I was going to chime in on, because we have also, it's not just Section 7 of the Charter, we have Section 2B, freedom of expression and freedom of conscience. And ultimately, I think Dennis McKenna summed it up real well. He says, well, you can have a symbiotic relationship with raspberries, which is a plant. You can eat them, just like you can have a symbiotic relationship with, the two plants that make up ayahuasca. And then ultimately, that should really come down to the individual's freedom and choice with respect to that right and access to something comparable. Now, David is right. Our rights are limited to minimal intrusion by the government. But I would argue that just as we've seen how bad law, like residential schools, which was validly passed, valid law at the end of the day, and the rule of the land, and validly assented to by the Queen and Parliament. Couldn't get much more legal than that. And we're seeing very much like the history in psychedelics is wrong. And so I'm of a different opinion that we shouldn't all rush to be so regulated so quickly with, hey, regulate us. It's almost like, hey, you have some explaining to do for why 1971 is carried on as long as it has. And really, until government get, I guess, hip to the issue and start moving on how they're going to regulate and legalize this, then it's going to take creative lawyering to try to do exactly like what the Native American church did in Quanah Parker, which they effectively realized, damn, these white people are going to exterminate us and our culture, our way of life, and so on if we just go gently into that good night. And so ultimately they took the Catholic religion and like, look, that seems to be what white people all belong to. Let's take that established religion and then we'll merge our peyote and shamanic traditions and the whole shooting match that has to do with our culture and way of life and fit it into a structure that, well, the white government in Washington would recognize of the day, and then therefore we have Native American church. So I again encourage First Nations to take a page from that very book. Like, use what you can, right? If the precedent box exists of Christianity, exploit it to the fullest as the vehicle by which you can populate with your cultures and traditions to get that status that if David, Jennifer, and I were to try to conduct these activities on off of banned land and so on, I mean, there would be different penalties and legal considerations. But I think the point is that, yes, I truly believe, just like cannabis, access to these medicines are a birthright. We've been so out of touch with this birthright because of 97 plus years of prohibition, which those 97 years took us away from medicines that were common everyday practice. And psychedelics even more so. So to me, I'm of the opinion like slavery in residential schools is wrong. We need to now recognize that, and we need to now move forward. And that's where I think this is a really exciting time. We will be moving forward. And if the last point from my end, if government doesn't get it or move on it, well, I'm lucky because I represent clients that I like to call in the front yard. But also by virtue of where I sit on the porch, got full view of everything going on in the backyard. And let's just face it, the backyard isn't waiting for anybody. Chances are someone within that number will get arrested. And out of those circumstances, whether if it's on reserve or off reserve, we'll have charter litigation to hopefully move things forward faster than we're currently seeing.
Yeah, I've got a couple of questions for you around that, but that we have a few more before we go there. And that co-opting, I think it's been done before, Rob. It's just something about, you go back centuries and centuries. I think the the Catholics and the Christians kind of did that already. So it's really quite poetic that we should be talking about doing it in reverse. Carry on, David.
Yeah, before we leave this topic, and responding to Monique and someone else in the chat, someone mentioned, it might have been Monique's question about, well, when there's money involved and people want to correct things like PTSD, that's happening. MDMA will be a prescription drug. My guess is 2 years, maybe it'll be 3 or 4, but MDMA will be a prescription drug. Psilocybin will be a prescription drug. The question was unfettered access, which to me means I'm an adult, and to respond to another comment, no, I don't get paid to show products online, but I just love that these exist, and I really like that our country did that. But I can buy this. I did buy this because I'm allowed to, because I'm an adult. We don't have any guarantees that psychedelics will be regulated that way. They might, but I don't think we count on it. And then the other one, the religious question, again, I don't consider that unfettered access. If a group or an individual is allowed to use ayahuasca or is allowed to use psilocybin or peyote, by the way, peyote is not a controlled substance in Canada. Mescaline is. The Lophophora williamsii cactus is not. But if someone has the right to use that religiously, that's fine. And there are subsection 56(1) exemptions that have issued for religious reasons. But again, I think the question was more about a constitutional right to use, full stop. And that I do not think exists. But after regulating, I'll do it one more time, cannabis, we certainly have experience as a country that would help to regulate a product in that category. And as Rob mentioned with the back porch, it's happening anyway. I had a lot of people, I'm in Alberta, then notwithstanding Alberta's landslide participation in medical cannabis access prior to the Cannabis Act, the average person here, at a dinner party, kind of made me their punching bag a few times, not only because they hate Justin Trudeau, but because they think legalizing cannabis was a mistake. I shouldn't say legalizing. It was legal already, regulating it as a consumer packaged good with no medical use. But what was happening was this. Some people thought it would just go very wrong when we regulated this. It didn't. And I think we could probably do a similar thing with psychedelics. And to Rob's point, it's happening anyway. And the point that I was constantly getting beaten up for at dinner parties was, oh, well, what about impaired driving? But I don't know a single person who waited for the Cannabis Act to pass to begin driving high, right? Like people who are going to participate in irresponsible behavior, they're going to do it regardless of the legality. What prohibition does is it removes options from people who choose to obey the law. And that's, I think, much to everyone's detriment with respect to the value psychedelics can bring to someone's life, whether or not they're traumatized. The people who are traumatized will be able to access therapy, and they'll be able to do it without an exemption or without participating in a clinical trial. It just won't be this year.
Okay. Lots of questions coming in. Thank you for those answers. This is from Justin Akaro. How can a non-expert contribute to developing legal pathways for substances like psychedelics? Is it necessary to be a legal expert, or can a group of advocates who understand the cause from different professional careers come together to develop pathways? What can they do? Jennifer.
Join the CPA or MAPS. Yeah.
Yes, Justin, join the CPA, and we'll work together to do that. Anybody else want to answer that?
Yeah, stop asking for permission and just get involved. You don't need to ask for anyone else's endorsement. I think it's important to understand what values are important to you and align with groups that are doing that work, but by no means should you limit your participation or be under the misunderstanding that you have to have a title or a certain degree of education or a qualification. I mean, absolutely not. it's really it takes a broad and a wide range of views and opinions and perspectives. And so that's why I say don't wait for permission. Step forward, understand what's important to you, and look at the greater picture and decide what role do you want to play. And then when you make up your mind what that looks like, then proceed with unrelenting conviction until you achieve your desired goal or outcome.
Thank you, Rob. And for sure we'll find a place for you at the CPA.
And I'd say develop a skill, be good at something, because at the end of the day, just being interested, it's not a skill. So whatever it is that you do, just be very good at it. I mean, at Psygen, one of our most important people is a supply chain manager. You know, she didn't train to work in psychedelics, right? So I'd say match skill with conviction. And yeah, like Rob said, just don't give up, and just and educate yourself about psychedelics. It's a massive topic. You know, really educate yourself.
We look forward to hearing from you, Justin. Okay, our next question is from B. Lier at the University of Alberta. Psychedelics, including psilocybin and DMT, are easily available for sale in Canada in several provinces. Prima facie, this seems reckless, particularly for the sellers. However, with proper support and funding, could this flaunting be a legitimate pathway to decriminalize psychedelics via a criminal court challenge? A criminal court challenge. Up your alley, Rob, this question?
I didn't think you wanted me to speak again.
I love it when you speak.
To be honest, I think we're going to achieve more in criminal court with respect to the movement of psychedelics in some respects, because if the action takes place in federal court, then the ruling is binding across Canada. So you don't end up having what happened in the dispensary constitutional challenge test case, which, you know, the Chief Justice of the Supreme Court of British Columbia can elect not to decide or consider the charter issues. It's that easy. So really, I think sooner or later, someone's going to make a complaint. That means then police will start looking at businesses or how these people are getting these substances. And then there will be some arrests. And out of those arrests, we'll end up effectively moving the needle a lot faster than, and with all due respect, like groups who have done good work, but unless you're terminally ill or the deepest, darkest depression, there isn't much representation for these other wider issues. And I think that is going to come from groups who are prepared to go the distance and then frame what they're doing in a manner that if arrest happens, just like what happened with cannabis, then if it's done in the right way, and that's all I'll say, then you can make arguments. But if it's just done in a way where it's unfettered selling to anyone, whoever, without any type of medical safeguards and, again, self-regulation, it's not going to get you very far.
Mm-hmm.
But yes, this is the type of thing that happens.
And just a point that Rob was alluding to, the Allard case was a federal court case. So the case, they most probably our most important medical access case, right? You can comment on that, Rob, if you want, Rob.
Well, no, the last point, that's a great point, because there is no such thing as like a silver bullet, one knockout punch, right? I mean, if we look at cannabis, most people are only really thinking of the last 2.5 to 3 years. Like, oh, what? Cannabis is going to be legal? Oh, it's set for October? Wow, that was quick. But what they don't appreciate is the decades of little wins, little victories. And so, yeah, the cannabis litigation, 2001 with R.V. Parker, then through Stephanopoulos and Barron, through up to, many others, to really, Allard and Smith, which that litany of litigation, took about, 15 years plus the Liberal Party and the Prime Minister, or a Liberal, Prime Minister candidate, campaigning to do this very thing. So it was almost like a number of perfect storms lined up, which led to the recreational legalization of a controlled substance. Now, if we flip the script and apply where we are with psychedelics, first Section 56s for Theracil were August last year. There is no right there is no right for any kind of production. I mean, Terry Parker was allowed to produce his own cannabis. In this case, Dr. Tobe or any of the other licensed therapists have to effectively, they're licensed to possess, transport, destroy, and so on. So, we're going to need a series of more little wins, right, to really crack that open. And nothing happens faster than when you combine a Section 7 charter case with Section 24, which effectively declares the provision unconstitutionally compatible with the charter, and it gets struck out to the point that it's no longer incompatible. So to me, that's really where the rubber hits the road, is also when there's threat of incarceration. And so right now you get busted for possession with, more than just a baggie of mushrooms. You could be looking at some serious strict CDSA time. And that threat of incarceration, that deprivation of life and liberty, is again another factor that triggers the Section 7 charter litigation. So, I mean, either way, again, and David's right on that point about being good at something and being a professional or being, good at it. Because to me, my day job, I'm a lawyer, right? I mean, there's routine legal work, and whether or not it touches the psychedelics or not, it's the same. It really comes down to what do the regs say, what does the law say, what does the common law say, and anything else in there on that point. But there you have it.
I'd like to maybe put something else for you to think about, Rob, and comment on, because you certainly have more experience than I do in charter challenges. But it's almost interesting to me how two things happened. There were subsection 56(1) exemption applications were made, and they were issued. They were not denied. And then the second thing, also in August of last year, is Chapter 5.13 of the Public Prosecution Service in Canada desk book was introduced. And it basically says, now this is just so everyone in the audience understands, this is not directed at law enforcement. Law enforcement see you in possession, and they're doing what their job is. They should arrest you. But once it goes past law enforcement, a Crown prosecutor then has to prosecute you and give you a criminal record and whatever sanction or punishment the court wants to put on you. The Public Prosecution Service of Canada's desk book, which is policy, it is not law, and I'll leave Rob to comment on the implications of that. It says, hey, prosecutors, if there's a drug possession case on your desk, do not seek a conviction unless there are extenuating circumstances. And some of those extenuating circumstances, to paraphrase, would be if you're in possession at a school, perhaps with intent to distribute. If you're in possession with intent to drive. And one of my personal favorites, if you're in possession and you're a uniformed police officer on duty. In circumstances like that, the Crown prosecutor is to seek a conviction. But Rob, do you think that by discouraging convictions, whoever decided to put that chapter there could be stymieing or frustrating attempts to get in front of a judge?
Not really. You're right on all accounts, and the rationale behind the prosecution is, the Jordan case, right? That if you're in custody for longer than a certain period, you haven't gone to trial, then it's effectively a miscarriage and mismanagement of justice. So you had a lot of cannabis cases that were getting dropped because of the Jordan rules. And, you got to remember, as interesting as the whole drug issues are, they're kind of low on the government totem pole with respect to the hierarchy of needs and wants and requirements when it comes to being reelected. So really, it's the optics of murderers walking because the system's been tied up with people like, I don't know, they got a little bit too silly at Nashville North during Stampede and had on their possession. Is that really someone that you want, a first-time offender, to put through the criminal justice system. So it's really designed to give latitude to make that point where police have decided they're going to recommend charges, and when the prosecution decides to recommend them. So that's where I get, well, I paid a lot of money, is at that point where it's still in the decision between the police and the Crown deciding to approve. And that's really where, if the optics are there and you're able to discuss with the prosecutor, really it's first question, well, what do you want? Like, what's this going to solve at the end of the day? What do you want? And if it's literally Jamie Bacon, for example, that they've caught with a pound of or a bag of mushrooms on him, then no, that's going to be the in, and they'll use that to nail him as they did. In the case of first-time offender who really shouldn't be in the criminal justice system, and prior to the abolishment of mandatory minimums had to be there, and a judge couldn't do anything about it, it really it really comes down to who and what and how do we want to use our limited and precious criminal justice resources. And so on that note, it does send a mixed signal. I mean, it sends the signal to the prosecutors like, hey, only prosecute organized crime and Bacon Brothers and when the whole truck is loaded full of it, kind of a thing. But to the public, and you're starting to see, I think we're at our 6th or 7th shop now in Vancouver that's just popped up selling mushrooms. Well, it really will come down to, will the VPD arrest these people, or will they go like they did with the cannabis dispensaries? They didn't want to arrest anybody, because if they did, that would have immediately triggered Section 7, and we would have gone boom right to federal court, and that wouldn't have played out. So it really is for policy reasons. And well, why it's dangerous is that people are now going to ramp up and do a whole lot of things based on a difference between legalization and decriminalization, and then of course no active regulation, which takes a decriminalized product and then regulates it.
What a conundrum. You just reminded me, Rob, that we had a really interesting panel at the Catalyst conference a couple of weeks ago, and one of the people was the inspector in charge of organized crime at the VPD. And when I first invited him to join the conversation, he said, look, we're just not interested in psychedelics. Yeah. Why not? Well, organized crime isn't interested in psychedelics, so we don't care unless someone's hurting themselves, and that just doesn't seem to happen.
So true. Like I'm lucky. I grew up with a buddy of mine who's an 8,000 light grower. I mean, he was probably the biggest grower west of Montreal in those days, and he was still is like Walmart, but 9 times out of 10, organized crime would rather be selling oxys and steroids in the valley than they would dealing with any of this, which ultimately begs the question, why, since 1971, in light of everything we know now, and it's really almost like we all know what this is wrong, how soon will the government react to it? And I think we're on our way, but there's so much work to go.
My next question, unless you want to say something on this topic, Jen. No. Okay. And there was something else you just said, but I'll skip over that and go to this. So it's really the why, and it's almost like a whining why, because this comes actually from our board. We had a board meeting this morning with the CPA. We meet every couple of weeks, and we were talking about this panel, and one of our board members, Dr. Crisco, said, okay, here I am on my soapbox. Elected representatives are not doing the job we elected them for. They pass their responsibility to the Supreme Court. How can we hold them to account? Anybody got a good answer for that?
Sue them.
Sue them. So then the issue with, we knew you'd say that. So the next question, follow-up question, is the issue with going to the Supreme Court, as identified by my fellow board members this morning, and I'm putting this out to you guys, is it puts a hold on all the exemption initiatives. Is that true? And comments, please.
I'm not.
Let's David. Panel of lawyers? Are you kidding me? Carry on.
Well, no, I'm trying to understand how there is, I guess, the connection or the association between the 2 points that has led Dr. Crisco to come to the conclusion that I guess she's come to. Because to me, if you were to look at that from a statistical point of view, it could possibly be answered as being an ecological fallacy just due to the fact that, well, the Supreme Court is the ultimate law of the land at the end of the day. But I don't think it's really a question of our government not doing their job. They're so busy juggling. Like, I'm pretty hard on government, to be honest. But by the same token, I also recognize how invaluable government are. And I've worked with a lot of government. And in fact, government was key on the Therasil initiative, from the point of view that, Paul Manley, Elizabeth May, a number of others from other parties that all spoke out on the issue and lended support. But I mean, they're limited.
True that they only do that until they're in power, and then all of a sudden they start shrinking violets. No, that's not true.
Well, I think, again, Trudeau has been a kind of a failure and a disappointment in many regards. I mean, sure, he legalized, but the way he's done it, and like this ties back into the whole psychedelics. It was the conservative government that effectively brought in Section 1.1, limiting new drugs and restricting new drugs that contain Part J substances. I mean, that hasn't been amended. And Therasil's still operating against that backdrop. And the government could change that today. I mean, we called Elizabeth May and said, you know more about parliamentary procedure than I ever will. Do you need, can this be amended, a regulation, the food and drug regulation, be amended by an order in council? Or do you got to go through this whole rigmarole? And she says, no, absolutely not. Patty Haidu and friends could amend that today if they wanted to. They haven't. And then, of course, the reason that all of our Part J psychedelic substances like, psilocybin and so on, they're on that list because the conservative government and Rona Ambrose, which led, of course, to the, help me out, Jillian, the heroin case.
The heroin maintenance program?
Yeah, the Providence Health case, which ultimately they had to argue, well, using heroin to treat heroin addiction, you've now made impossible by closing and reducing the special access procedure loop. So the point I'm trying to make, and I apologize for lack of brevity here, but really, Justin Trudeau, the day he came in 5 years ago, could have amended this. He could have removed these substances, put the SAP regime back. They could have removed the Part J substances, and then through order in council, the health minister could remove 1.1, which then really begs the question, why was Therasil's Section 56 request and the others that have been requesting access to these medicines been denied? And so Therasil's at this interesting catch-22 where they have the ear of the government, they're working with government, they're slowly making some change, but with all due respect, it's not really the same thing as having sued the government like we were doing and bringing a judicial review, because the result of that would have been as follows. Unlike cannabis, which now Parliament is actively regulating and has legislating, there is nothing like this for psilocybin other than an absolute prohibition, which means the door was shut. If we had brought the charter challenge the way that initially we would have, and if we had won, at least at first instance, and if it had made its way through appeal, or we'd won at first instance, then there would have been a greater chance that the courts would have decided in our favor. They would have ruled that the government's absolute prohibition of psilocybin is unconstitutional for Section 7. Any of these other restrictions could be validly set aside by the Section 24 application. And that would have forced the government or the courts to then send it back to the government. And the government would have had to have addressed this, right? And they would have had to have addressed this in a more comprehensive manner than the can of worms that we're left with the Therasil situation in that respect. And David can certainly take it forward because he's still actively involved with Therasil in that regard. But the point that I just want to end on is that we're kind of now at the mercy of what Therasil decides to do, as opposed to taking on an absolute prohibition and having the government decide. And I guess that ties back to Dr. Crisco's question, that government that way is how they're held accountable, really.
How they held accountable. That was her question. I just want to say to you guys that I have to be like removed as the host and moderator because we just ran out of time. So it's 5 o'clock. It was just, so I'm just wondering if we could go and complete this conversation, because it seems rather not okay to not do that unless my tech people say otherwise, and just say we're going to complete this conversation and then close at like 10 after 5. David.
Yeah, so and just I saw a question in the, not in the Q&A, but in the chat saying, isn't this already proposed? It is. And when I say it, what I mean is it's been proposed to remove the qualification that restricted drugs cannot be part of the special access program.
I know, but it's been years.
It's been 3 months since 4 months now almost since consultations closed.
MAPS Canada sent a letter. So when I was on the board to MAPS Canada, we sent a letter to them at least 18 months ago. Come on.
Oh, yeah. Yeah, no, I have no doubt. But I mean, the consultation opened in December. I co-signed both Therasil and Psygen's letters. That's on, you can find that if you Google it. And, but I understand completely what Rob's saying. Right now, some exemptions have issued. All it takes is a change in policy or government or leadership, and then those exemptions may stop being issued, because exemptions are issued at the discretion of the minister. However, I'd say that once you let some people have them as a government, if you suddenly stop, there are probably more significant constitutional implications than if none were ever allowed in the first place. So what I think is that if there is what in my view would be a poor choice by leadership to cease giving Canadians who have a real reason to possess and use psilocybin for medical purposes, if there's a decision to stop issuing those exemptions, I'm pretty confident that the argument to do better, you know, the argument that our government needs to do better would speak louder than it would have had they never tacitly admitted by issuing these exemptions that there is a reason that some Canadians should have it. And if you all of a sudden have a Canadian with a similar set of circumstances who's not allowed, I mean, Rob, don't you think that the constitutional argument that could follow such a refusal today would maybe speak louder than it would have had no exemptions ever been issued?
No,
okay.
Because of the legal principle, David, which you have to remember, that Parliament is really subject only until cannot be a fetter unto itself. So it means that sitting Parliament can amend and change previous Parliament, and they ultimately can't be bound in a situation, or the courts will give more deference in a situation where the government has actively decided to regulate. And that's why it's an absolute bitch, for lack of a better analogy, to take on a cannabis constitutional case now, because the government has actively and declaratorily made law, and the courts have to give credence to that and deference because of respecting the separation of powers. And of course, excuse me, the prerogative, powers, and privilege of Parliament. You know, they can be wrong. They just can't be so far wrong that they're ultra vires. But of course, if it's an active, deliberate will of Parliament, just like this has been with the Therasil, okay, and any type of regulation of this, ultimately can be interpreted as a direct will of Parliament, making an attack against an absolute prohibition, is the point I'm trying, more difficult, is where I see it. Because again, if you've got a closed door, you can kick in the closed door. But if it's open just a bit, a crack, which it is now, meaning that, you know, there's government regulation, then the courts will have to infer that Parliament's doing something. That's where it can get sticky, because one branch of government does not want to outpace the other. And that's just the reality of our system, because everyone's kind of making it up as they go, is the honest truth.
So can I ask you one? one last little clarification, because we really should conclude, is if Rob gets his way and takes a case to the Supreme Court, does that put on hold all the other initiatives like Therasil? No?
No, because it really, I look at it like Grand Central Station. I mean, you can bring as many challenges, but if you bring a lot of frivolous challenges or challenges that dilute or weaken your argument, and that's the beauty of law, is it'll take a novel, unique situation based on the facts that end up changing and displacing the pre-existing law. So to me, it's all really going to come down to the facts. And that's why you can't look at this as a cookie cutter carbon copy of what happened in cannabis. We can only just look at, okay, how were these rules and precedents and the basis for them, and were they actually carried out the way that they were intended, and have at least that foresight to see how close or far from the mark things happen with psychedelics in future.
Do you know what else I just realized? We used to have till 5:30.
I thought we had till 6.
No, it's 1.5 hours.
Oh.
Sorry. I've had so many different times given to me today for a variety of reasons. Just please excuse me. This, I don't know why I just did that, but I did. So, should we move on to another question, boys and girls?
Oh, hold on. Rob, how about failure to process Section 56 application in a timely manner?
Well, yeah, that's another tool on the tool belt. Just like you have failure of, again, administration of justice. Has there effectively the delay been caused by issues of, for example, irrelevant considerations, factors of bias, things like that?
I'm just talking about processing in a timely manner. And of course, it's federal court, right?
Well, I think, it's more, that's again strikes to the heart of why there needs to be some coordination and harmonization of these efforts. Because if you get 30 bad cases before a judge, when you could pick and cherry pick the elements of that and then involve groups like MAPS Canada, CPA, Therasil, the Canadian Fair Drug Coalition, Canadians for Safe Access, all of these groups to appear as intervener access, then what gets a lot more entertaining for me is, again, playing the role of air traffic controller, where now you get to bring this coordinated strike of state, non-state, public, private, for-profit, not-for-profit actors effectively amounting a campaign against the federal government. And what I loved about being legal counsel during the test case, we had like Kirk Dusaw was another co-counsel, and Dean Davison represented all of like Don Briere's interest. And we flipped it on them because there's one city hall, but there were 67 dispensaries and 3 lawyers. It was the ultimate game of risk. And I really think that the odds are very much in our favor, again, should we as a community and as a collective of concerned citizens who want to see the right work done here, start coordinating those efforts. Because look, if you mount your own, as a group, your own D-Day style of coordinated approach, I won't call it an assault, we'll call it an approach, the government then has to deal with it, because bringing the action requires, under the Constitutional Questions Act, you have to then notify the Attorney General of Canada and the Attorney General of BC. And yeah, they don't respond to 90% of mine, they won't appear, but there are those few that they do. And then you've really got something. So that is where I think we can take all of these groups and all of these pieces and really begin to figure out, okay, how do we want to slot this? Because we've got all the elements needed.
You make a argument, Laurie.
And then if a case is denied?
Well, then you've got to ensure that you satisfy the twin pillars. We really should have, I see Catherine
Vavilov,
is in the group. She should really be up joining us on a future call. She's the lead attorney in the U.S. with working with Sunil Aggarwal, bringing the right to try case against the DEA. So again, these are little wars, coordinated battles, and that's really how I look at this from the point of view of the lawyer advocate. Is, hey, that's where I exist, is already behind enemy lines. Right? It's coordinating these groups and teaming up with the different law resistances, as well as with the right combination of legacy participant that knows what they're doing, with, of course, the right regulators, experts, and scientists, because you can't just roll up there, breaking the law, boss. It doesn't work that way. And so I don't know, that's where I'm hoping we can start as a community coordinating these efforts. And then from them, we can have spin-offs of other campaigns. Because I know Jennifer and you and David are very much interested, given David's background as a scientist and a patent attorney, and your background with regulation and dealing with government process. There's nothing I would love to see more than that. But in order to get to where we're in a playing field where we can do that, I mean, we're going to have to drop the gloves. And, I hate to say it, the government isn't going to come up with this on their own. It's really going to take a lot of persuasion. And like I say, if they don't answer when you knock on the front door, well, you can usually backdoor it with the courts and go through that way. And I think we need to have both. Approach the government, and but at the same token, if they delay and there's failure to comply and all these other issues, then we got to hold them accountable. Because if we don't, then look at other historic examples of government failure.
Well, I'm sure there's many of those. Okay, thank you, guys. So next question from Laurie Perth. What happens after the local city council approves decrim motions, and how can the community support next steps?
Oh man, that's going to be open the floodgates and welcome to Vancouver 2015. You're going to have 100+ dispensaries, and I don't know if we'll be any further or closer to our goal, but I'll be busy. I get calls every day. Are you going to come out of retirement? You're going to represent mushroom dispensaries? And I'm like, well, we'll play it by ear.
How about you guys, Jen?
I don't think I have a comment on that one. It's because it's such a jurisdictional issue. City versus province versus federal government.
Like, what's it going to be, really? Right? Those that are doing drugs and possessing drugs, right, are doing this and are going to continue to do it. Whether the amount is X or Y doesn't really address so much of the issue of clean, safe access, as well as, consumption lounges or places to do this, as well as how do you take these activities off the street but have them still at the same time safely regulated with some degree of supervision, so that, again, you're not adding to the prosecution's workload with cases that shouldn't be there. And I don't know, I really think that Mayor Kennedy Stewart is really missing the boat in some respects. He has to do something. And I'm not blaming him for not doing it, but is this the right step? And is that going to get you the cred that you really need to work with the federal government to do things of greater consequence than just, make it a little clear for the problem you already have to deal with, which is possession by people who are going to possess regardless because of other issues.
David?
Okay. Sorry. I was just going to say one thing I really do like about it, even though, as I know David's going to say, the city really doesn't have the power to do this. They can talk about it. But the initiative, what it does was a little further prompt to get the provincial government to dialogue with the federal government. So I thought it was really it was nudging the province out through the door, so to speak.
Yeah, and just for the benefit of people that are watching who are not lawyers, federalism is a concept that means we have two levels of government. Federal, like Canada can declare war on another country. Alberta cannot declare war on another country. Canada can't tell Alberta how land use should work in Alberta, right? That's up to Alberta. That's a provincial issue. Municipal governments are a delegation of provincial power. So the Alberta government can't tell Calgary what the speed limit is in Calgary. Calgary has the right to decide that itself. In Canada, I see a lot of chatter in the chat about U.S. issues from Catherine Tucker, who's a lawyer working in the space in the U.S. In the United States, you can have the death penalty in one state, but not another. Just like you can have an adult use cannabis system, or for that matter, a psilocybin regulatory system in one state, but not another. Canada's not like that. In Canada, if something is criminally prohibited in anywhere, it's criminally prohibited everywhere. Our criminal code is national. Now, that enforcement priorities matter. We all know that the Vancouver municipality had a low enforcement priority on cannabis. They might have a low enforcement priority on psilocybin. If there's 4 or 5 stores openly selling it, that would suggest they have a low enforcement priority. But they can't decriminalize it. They can't. And that's why, any more than they can declare war on another country. And when I say they, I mean the city of Vancouver or the city of Kingston or anywhere. They can apply for a subsection 56(1) exemption to allow all people present in the city to possess. And if Health Canada, the regulator, decides they're going to allow that, then they can. That's up to them. And if they decide to deny it, then the municipality of Vancouver would be free to take them to court over it. And if the provinces talk to the federal government and the federal government decides to put in the Controlled Drugs and Substances Act that a province has the power to vary it, just like in the Cannabis Act, the provinces have the power to regulate sale. That's in the Federal Cannabis Act. If that were not in the Federal Cannabis Act, then the provinces would not have jurisdiction to decide on how adult use sales work in their province, unless they asserted it under the Constitution. But it's much simpler if they don't have to. The Cannabis Act is written with a recognition that the way a store works in Alberta doesn't need to be the same as the way a store works in Quebec, to take probably the most and least cannabis-friendly jurisdictions in the country. So, all that to say, if a city decides that it's a priority to stop arresting people for possession of controlled substances, then the city can set enforcement priorities, but they can't change the law. Vancouver is trying to get an authorization called a subsection 56(1) exemption so that it is the law inside Vancouver. But that is entirely at the discretion of the Minister of Health, who is the federal government.
Thank you.
So there isn't really a lot they can do without the federal government's cooperation.
But you got to remember, Vancouver was a city and a chartered city, I believe, before British Columbia was even a province. I mean, it was New Caledonia back in those days. So you have the Vancouver Charter, which is slightly different than the community charter, but your point nonetheless holds with respect to the criminal law. But it's interesting. What about if the province, and I've been trying to, make the argument that the whole reason we have legalized cannabis anyway is because of really one province, British Columbia. And under Section 9213, which gives provincial trade and industry, I'd like to see John Horgan, for example, say, look, federal government, fine, keep your Section 91 medical and the criminal law, but recreational cannabis, which has nothing to do with your federal arts of power, is provincial, right? It's effectively just like the BC lumber industry, pulp and paper, tourism, forestry, mining. I mean, Canada's an interesting country, and you'll appreciate this, David, being an Albertan. And one of the reasons why Canada is like one of the few G7 countries that does not have a federally regulated securities exchange is because of this and this reason only. Do you think that Alberta, and again, the flow of oil, is controlled by publicly traded companies Do you think that Alberta for one moment is going to delegate that type of control and authority to the Ontario Securities Exchange? Absolutely not, which is why as a British Columbian, I'm of the opinion that under Section 9213, recreational cannabis sold within British Columbia could very well be regulated, or the case could be made by the BC government. Now, the case could be made. Whether they would be successful, again, we could debate that till the cows come home, but a case could be made. And ultimately, that's where, the states in the US seem to have greater power when it comes to effectively regulation of industry within it. So I almost look at what we have in the States, and correct me if I'm wrong, David, but it's like Canadian federalism is kind of like an inverse of American federalism with respect to the powers the states have versus the powers our provinces and territories have.
Which is consistent with Canada's far smaller population.
So I'd just like to answer that question about what can communities do, and does it really mean anything? I just go back to my old drug policy reform days when there wasn't the internet, and we used to say, let's talk about these things so that when and let's have a conference, let's have it be like in the zeitgeist that people are talking about it and calling for change, so that when the minister opens up his newspaper, remember when we used to have those, they would read about it and they go, oh, I see. And remembering that one of their top priorities is getting re-elected, they would realize that there is a swell of support for whatever the issue is, and that will help them move forward. And I do think that's what these municipalities can really create, is that swell of support across the country to pressure and maybe invite, an ambitious politician that wants to get re-elected. So what do you think about that? Oh my God, they're speechless again.
Oh, dead air. I don't want to always be the guy that jumps in.
Jennifer, would you like to comment on that?
No, I was going to comment on Rob's previous comment about federal provincial jurisdiction, and that the provincial government can negotiate an accord with the federal government, particularly when it comes to cannabis under the Cannabis Act. That there are provisions for that. The province just hasn't taken them up on it.
Why haven't they?
You know what? I think I think that it's just taking time to get used to the idea of legalization. And the rollout, it's taken them a lot of time. It's they have to digest it all. I think that there have been small little efforts, like Community Futures in Nelson, BC, to help micro processors, but there's no provincial policy or process to facilitate cannabis production. They could.
Yeah, and I applaud those efforts. The problem ultimately is, for these groups, is sure, they've got the special co-op status, like take the Kootenai group. Does that render them competitive, though, and in a position where they can be competitive with international markets? And that's where I think a lot of the BC economy, when it comes to what will be international recreational cannabis production, is very much under the thumb of the federal government. And so that, to me, is where I think when COVID is behind us and John Horgan and Mr. Farnsworth have a lot more time to look at this, I'm hoping that they're going to look at making the BC recreational cannabis economy flourish, because ultimately the real sales and opportunity will be international sales, just like there is for BC wine and other BC products. And that, to me, if we try to pigeonhole ourselves in something that we shouldn't be, well, that's going to make us even less competitive with cannabis production when it starts in India and Pakistan and Honduras and China and Mexico and everywhere else. I mean, I think what the key is how do you make BC competitive? And well, we got to be realistic, and the government has to be realistic that these regulations are not working. And for the sake of the BC future, we've got to look at something, because failure to do so is akin, and same with Alberta. I mean, the Alberta legal cannabis economy is impressive, but they're very much like, I would say that like BC, they're too are first class passengers on the Titanic, that if they don't do something now, then they'll be doing something about it slamming into the iceberg, which will be how uncompetitive we are due to our regs versus what will be coming out in future.
I think it's important to recognize, though, that it's been 30 months, right? Like, everyone in this room gets it, but go talk to someone who hates cannabis and has never used it. And thinking back to my dinner parties prior to the Cannabis Act being incorporated, and by the way, they were not my dinner parties. They're ones I was invited to. I wouldn't invite people. Anyway, point being...
Oh, I would.
The liquor industry, I don't remember this because I was a child, but I guess in the 70s, you know, a liquor store did not look like what it looks like today. I'm from Saskatchewan. Private liquor stores, I left the province before those existed, right? Like, I've seen in that province, in my home province of Saskatchewan, the liquor industry change, and the cannabis industry will too. I mean, it's not going to look like the same as it does now forever, and I think it's only going to go in one direction, and that's more liberal. So I hope that, and when I say more liberal, small L, of course, I just mean the restrictions are going to be less intense in the future than they are today, as everyone understands that these regulations do not need to be this intense. And I hope, for the sake of Canada, as a taxpayer and as someone whose children might live in Canada, I hope they do, that we will, you know, not do the same thing with our lead in cannabis that we did with our lead in smartphones. Because I really think that, you know, in the economics textbooks of the future, if you talk about emerging markets and disruptors, you might see Canopy and Research in Motion right next to each other. And as something that started in Canada and then was left behind quickly. So you're right, Rob. And I really hope that that's an issue that corrects itself. But I also think we're getting pretty far away from the topic of access to psychedelics.
We are. And in fact, we have now officially run out of time. Gillian has got her timing right now. And so we're around 5:30. It's time to say goodbye. There's way more questions waiting to be asked. I wonder if we could reconvene this in a month or two, because amazingly, you guys are incredibly entertaining and people love it when we talk about these issues. And I really appreciate you bringing these issues to life and making it real for people who want to understand the complexities and to see where they as communities can really, you know, make a difference and get involved. So,
Gillian,
yes,
I would recommend for a part 3, because this was our part 2. We should definitely extend an invitation to Catherine Tucker. I mean, she's been participating in the chat, but it would be really wonderful to have American Council in these discussions and learn a little bit more about what they're doing under the right to try laws and psilocybin suit against the DEA in Washington State. So, look no further. I think a part 3 soon would be great, but with the addition of Catherine.
How are you guys with Catherine joining us, David and Jen?
Absolutely, this has been great. Been a great discussion.
I've had discussions with Catherine in the past. I have a lot of respect for what she's doing, and I think she'd be a great addition.
We look forward to inviting you, Catherine, and thank the 3 of you for joining us and bringing us all your wisdom and all your knowledge. And don't forget, everybody, we are the Canadian Psychedelic Association. And if you haven't joined us already, please become a member and see how you can get involved in this amazing community that we're developing that's around us. Goodbye for now.